Well, hello, and welcome to another podcast by Eleanor. And today we've got Dr. Omar, Dr. Paul Omar. Thank you very much for being here today, Paul. You are involved in modules like contract law, land law, and equity and trusts as well on the third year.
Mhm.
But you also teach on the master's modules, quite a few. Um, there is one thing that you'd like to share with the students as well, that you like to travel. I don't think that's any secret for anyone in the law school, anyone that knows anything about you. And you're also, as far as I know, you are a lover of languages.
Indeed, I am. Yes, it's very kind of
Good,
you
good.
to mention. Yeah.
Um, so today we'll be covering an important topic, of course. All of them are important. That's why we're talking about them. But we will be talking about how to conduct a critical review of legal literature. So, my question to you, Paul, is why is this important?
Well, Elena, as you will know, and I think as the listeners will know, there are many building blocks that go towards understanding the law. And so it's not just the law in practice, for example, case law and indeed the statutes that Parliament passes and all the myriad of, delegated legislation and international treaties and so on. But it's trying to understand the law in action and what it does to reflect society's needs, to try and prompt society's development and so on. And a lot of thoughts about the shape of the law, where it has been, where it is, and where it is going is contained in the literature. So it's an indispensable, fundamental element to understanding the law.
Wow, quite crucial for any legal um, law student that comes into the legal field, I suppose. It doesn't matter whether or not you're becoming a solicitor, a barrister, you do need to know your stuff, and knowing your stuff means going into the literature, doesn't it?
It does
uh,
indeed.
but but what do we mean by literature?
That is the $64,000 question, Elena. I would like to take a very wide definition, which is that it is everything that isn't a statute or case law. So any form of commentary in relation to the development of the law, whether it's on a solicitor's firm website boasting about their recent cases, all the way to the highbrow journals where we're talking about meta law, which is not just the law, but what signals the law's development and everything else in between. Because there is a lot of material out there, not just the quality journals, but practitioner journals, websites, even blogs can be useful, provided that they are, of course, authored by persons who have something to say of quality. So, literature, I would say, can be defined widely, but classically or traditionally, um, I use the alphabet. So,
Mm.
A for articles, B for books, C for chapters in books, and D for documents and other things. So if you follow the alphabet, those are the four key constituencies of what we might call literature.
Wonderful. I like how you set that one out, and obviously you're allowing students to make their own notes and hopefully make a mental note of this so it's easily remembered. But what do we mean by documents? If we could just expand on that point a little bit more, because the others are self-explanatory.
Yeah. I'll give you a couple of examples.
Mm.
When a statute is passed, there's often an explanatory memorandum which sets out what the government understands will be the purpose of the legislation and how it is intended to work. Although it's not a very highbrow document, so the analysis might be quite shallow, it's still a meaningful insight into what the legislation is intended to achieve. You can have a case note, for example, that doesn't quite easily fit into the article, book, or chapter category. That
Mm.
is, descriptive as to the facts, but puts in a few insights because the person writing it happened to have participated in the case. So it's not the profound analysis that you might expect of a proper case note in a journal, but it
Mm,
nonetheless has valuable information.
brilliant. Thank you very much for expanding on that. Um, and why are we interested in a literature? Why do we want to have one in the, why do we care about literatures?
Well, that is a very good question indeed. And I think if you are here to study the law, and whether your ambition is to practice or indeed to teach it or to use law in some fashion, I have students, from where I taught when I taught at other universities who have gone on to become pilots for British Airways, shop fitters, international DJs, so a variety of careers in which you use the law. But the thing that is common to how we understand law is to be able to do your research, to be able to analyze, and to be able to communicate your findings to others. And those are the key skills, I think, that are embedded in every law degree. But
Mm,
the research and the analysis sits on understanding the primary materials, and that includes the literature, because the literature tells us where the law has been, where the
mm,
law is at the moment, and whether that's a desirable position, and maybe also where the law will go, because it's not static, it changes. Even land law with ancient statutes changes, although slowly. But many
mm.
other disciplines in law move very, very fast indeed.
Very true. Very true. Now, of course, an obvious question from a student might be, how do I find the literature? If I'm
Mm.
reading, of course, the literature is absolutely everything, depending on the topic that you're doing. So clearly, we can't go into that because we'd need a specific assessment in mind. But when you're looking for a literature, the
Mm.
literature, how do you find it?
Ah, now that's a very good point indeed, because we live in a technological age, and so the first recourse for many is what is out there on the World Wide Web. And it is possible to find quality information out there, quality literature that you could use for the purposes of your assessments. But you need to be very, very careful,
Mm,
certainly with respect to understanding who has authored it, what is their intent in so doing, and whether the material is biased or unbiased. Both
mm.
can be used, of course, but you have to be able to appreciate that you need to be able to compare between contrasting views. There is an easier way, though, which relies on the classic accumulation in legal databases. And we have many legal databases. We have Westlaw and LexisNexis are the main ones that most people will use, including in practice. But there are many others. There's Hein Online, ZTalk, JSTOR, all of which will have legal articles or articles connected to the law, such as in politics or in history or even in anthropology. So there's a wide variety of sources that students can access. But I would start first with those that are available through the library website, which are the legal databases, so Westlaw and LexisNexis. And then when you can, develop that quality filter, then by all means use what is available on the internet, because quite frequently
Mm,
those are very topical and very recently authored pieces that might contain valuable insights into how the law is
yes,
developing. But you need to be careful. The internet is a bit like the Wild West. You can pick and choose, and sometimes your choices may be the wrong ones.
definitely. I think many students get hung up on just using random websites, and that's not what we're looking for. We are looking for academic work mainly, but also work that is somehow of high quality.
Mm,
Um, in, not just any old blog that is.
yes.
And mainly depending on, especially undergraduate level, depending on the assessment, we would like students to go for journal articles because those are peer reviewed, and the
Yeah.
quality, the validity, of the information that they're writing is reliable because
Mm.
of the source of
Yes.
these journal articles, rather than just focusing on pieces that you find online, which you are not 100% sure whether or not
Mm.
they are reliable sources, because
Yeah.
anyone can write something online.
Oh,
And I think
exactly.
you
Wikipedia
said
is
a lot.
notorious for that. Yeah. Where
You
the
said a
articles
lot
can
about
change by the
quality.
minute. Yeah.
Yeah, you said a lot about quality. So I think how does a student make sure that
Mm.
they stick with literature that is of quality,
Mm.
of a high quality value for their assessment?
I think there are a number of ways of achieving this. The old way, and which is still valid, is to actually look at the quality of the journal and how well perceived it is or how well ranked it is. And so the articles that those journals would contain would also be of high value. Um, that's one way of doing it. Another way would be an author-focused way. So if you identify key names and key persons in your area of research, it pays to go and read other things that they have written to get an insight into their thinking. So that's a possibility as well. You could
Mm,
adopt a practice focused approach, which is to identify key members of the bar or key solicitors firms who have practice in particular areas. So if you were interested in maritime law, you would go to INTS. If you were interested in commercial law, you might go to Allen and Overy. And it's the same with barristers and chambers. Certain chambers have a reputation of dealing with the high quality, high end cases in particular areas. So that's also a possibility. But it pays to research. It pays to sit and spend time looking for resources rather than just inputting parameters into Google and praying that something interesting will come up.
mm. That's good. That's good. Going after it and knowing exactly where to look for it. I mean, it is a skill, isn't it?
Mm,
We don't expect students to just know this from the get-go. It is a
mhm,
skill, and you just have to keep going. Keep doing it. Talk to other students about it. Sources. It's
yeah,
nothing to do with plagiarism. You can ask questions. You can ask your
mm,
tutors. It's
yeah,
we're all learning at all times, so don't be afraid to ask questions, I would
exactly.
say.
Exactly,
Um,
I was going to
mhm,
add, Elena, that in
mm,
many areas of law there will be a dedicated, a module handbook or indeed a recommended text, and it pays to read the references and citations these contain because they will lead you to the literature as well. Um, so there's plenty by way of resources that are available to you immediately rather than instinctively reaching for your phone and Googling something at random. Sometimes it works. I mean, I'm not decrying Wikipedia, even though the pages are edited and you have to understand how the process works so that you have to have a bias filter there when reading Wikipedia. But quite often it's an interesting place to start because it
mm,
accumulates information, puts it together in a concise and reasonable way for you to be able to absorb it. So you get an insight, an instant insight, and then you can pick apart the elements and then you can go hunting for the proper literature and resources to explain those.
yes, and never reference Wikipedia in your assessment. Absolutely never.
Uh,
Wikipedia, law teacher, anything along those lines.
yeah.
That is not the place to go to.
Mm,
So, how do we make sure that we use it well in our work?
okay. Yes,
How do
indeed.
we use the literature well?
Well, it's not enough just to collect it, is it, yeah, Leila? You have to do something with it. And it depends on the type of assessment you're approaching.
Mm,
If you're approaching a classic problem question, then the materials that are the most useful are going to be the statutes and the case law, because that's how
yes.
the law is working in action for you to be able to advise a client. But the literature could also be useful because if there's an ambiguity in the law, or there are, in fact, two lines of jurisprudence or case law that essentially, stand at contrast with each other, then the literature might actually offer you an opportunity to understand the dilemma, to understand the problems, and you need to understand the thinking of the judiciary when it comes to using that case law. And if it's an essay question or indeed a case note or maybe something more complicated like writing a skeleton argument to appear in a higher court, then the literature is very useful indeed because you can directly take arguments, you can, you know, bearing in mind that you should be very careful not to fall into an echo chamber, you'll be able to see what the thinking is from an academic and a practitioner point of view as to where the law should be going. And you
Mm.
build on that to make recommendations, whether you're appearing in a court or whether you're writing an essay which essentially advocates for a particular outcome or a change in the law.
Hmm. Oh, that's very good and valuable advice. Very. Oh, I like that. Um, Now, a student might think, there must be some rules
Mm.
that I can follow or some tips that maybe you, Paul, can give us to make sure that we're conducting a critical review because
Mm.
it's one thing to just say whatever we know about the subject and quite another to actually engage with the literature.
Mm.
Just saying what's out there in the literature doesn't necessarily lead us naturally to a critical review. So, what are the rules or some tips that you might be able to
Yeah.
give to students?
I think the utility of literature is really in how best it can help you make an argument. And you mentioned plagiarism earlier, and one of the best ways of avoiding plagiarism is to have proper citation and referencing for practically every idea, statement, and argument that you're putting across in your coursework. And you should treat literature as one of these components. You can use the statute to say what the law is, you can use the case law to say how it is developing, but you use the literature really to be able to stand back and to objectively analyze the shape of the law and where it is going. So there is a process to this because in order to find out whether the literature will be helpful, you need to do three things.
Mm,
And the first thing is to understand the utility. Is this going to be a useful article for me to read? Is this going to be a useful book that I can reference? Is this going to be a useful chapter or a useful document to embed in my research? So to understand the utility, you've got to read it at least once so that the
mm,
ideas come out and essentially appeal to you, and you can start to see where they might fit into the arguments you want to make. And then second, you have to appreciate how those arguments are formed. What are the resources the author relies on themselves? And can also be a useful research technique because
mm.
if they identify literature on which they are basing their arguments, that might also be useful literature for you to go and see and to go and
So
look.
true.
Yeah.
Yes.
And then the third bit is to essentially understand why the literature is convincing, why it has instinctively appealed to you in that first stage. When you first read it, you go, oh, yes, this is going to be useful. The
Mm,
second stage is understanding the resources that are used to construct the arguments. And the third stage then is to determine, are you convinced by those arguments? And there
mm,
are very simple rules for literature, really, or how you embed these sources in your work. And the first rule is the critical one, which is you must always listen to the other side. So don't fall into the echo chamber of only finding the stuff that agrees with you. You have to confront the possibility that others might not. And how do you deal with that? When you're looking at
mm,
where the law is going to go, and there are two or three different possibilities, the judges will eventually choose, or Parliament might choose, when it enacts legislation. So you need to be able to say, well, which one of these would be the right outcome? Which one of these would be a good outcome for society? So you need to be convinced by the arguments that are being made, or to be able to deal with the arguments if you don't agree with them. Don't just dismiss them and say, oh, this is a hopeless article and I don't
Mm,
agree with it at all. Why is it hopeless? Why does it not appeal to your senses? Why is it not a good piece of literature? Or why are the arguments not convincing? You have to deal with those as well. And at each of these stages, I'm afraid you're going to have to read the article. You can't read a summary or indeed a footnote that somebody else has written about it. You have to read the piece itself. A first time to say, is this a good article that I can use? A second time to say, well, what are the resources that are being used here that I could possibly benefit from? And the third one, have I been convinced? And if you're not
mm,
convinced, if you're not convinced, you can still deal with that literature. You can say, well, why is it that I'm not convinced?
mhm,
So there
mhm.
is a process that you can go through to be able to bring the literature on board in the way you construct your coursework, in the way that you inform your understanding about how the law moves.
Yes. I think it's very useful, these three points that you gave the students, because when we're developing our writing skills, of course, critical review of a literature is part of it, but it's a bit more difficult than just writing an essay.
Mhm,
It's going to the crux of what it is that we do um, at university.
mhm,
It goes further into, you go in more depth, for example. This is not school, it's getting more and more difficult in terms of the materials that you have to use. And you saying that students, a good place is journal articles, and them reading these journal articles with these 3 points in mind also helps them, I think, to develop their own skill, their writing skill, critical analysis skills,
mhm,
to employ in the work that they're doing. And by reading these articles as well, you learn a lot about how to address your reader, how to
mhm,
construct your paragraphs, how, of course, not all of them are great. Some of them, read a little bit, they're a bit choppy.
mhm,
But the more you read, and the more you get acquainted with skim reading as well, because we're not saying read every single article you find. We're saying when you're doing your research of the literature, and I think that would be my one last question for you in a minute. But when you're doing your research of the literature, you're going to have a bunch of journal articles
mhm,
popping up, and you're not saying read all of them. We're saying read the abstract, but really read the 10, 20, however many you found, and you're going to use as the basis of your literature. But an abstract, for example, will or should straight away put you in a position where you're deciding whether or not, yeah, this is a good article, this is not a good
mhm,
article, this is not applicable, or I'm going to put it into my for pile or against pile. So you
mhm,
could, depending on the approach that each student has. So yeah, my last question to you would be, we're talking about how to conduct the critical review
mhm,
uh, of legal literature, but where do we start? I think for students, when you're thinking about it, I mean, for everyone, I suppose, even for us, when you're doing research and when you're preparing
mhm,
for a conference, the procrastination also comes into it, because you're like, I don't want to start it because look at all of this, this big piece that I need to write and all of this literature. So,
mhm,
do you have any tips for students um, as to where to start, how to start,
mhm.
to get them going, and not make them feel, oh, I'm worried about it, therefore I'm going to put it for as far away as possible and as close to the deadline as possible, which obviously
Yeah.
we don't want students to do.
Mm. Well, there are two aspects to this. I think one is the understanding what the aim of the exercise is. And there was a German philosopher called Hegel. And he said that all ideas start out with a thesis. So I'm putting an idea forward for the world to see. And then somebody will come along with a contrasting idea, and he called that the antithesis. But
Mm,
those two ideas eventually will merge, and there will come a fresh idea out of that combination, which he called the synthesis. And that's the process really that we want students to mimic. We want students to contrast ideas, to be able to comfortably deal with them, and then to provide a synthesis that explains how the law is shaped, how it moves on, how it is formed, what relevance it has for society, and so on. And,
mm,
through the coursework to essentially reflect on this. So there's a purpose to it. But where to start? Well, like I said earlier, one of the simplest ways is essentially putting search parameters into reputable legal databases and just see what comes up. And you will get a feel for the literature. There may be many, many selections that will come up. And you might want to order them in some form of priority. So maybe recent literature,
mm,
maybe literature authored by certain key people that you've identified. For example, if you want to look at the current state of international law, just read Philip Sands KC. He's authored many, many books and he writes very, very frequently. And if you want to learn about family law, certainly during the period that she was an academic, then Brenda Hale, Lady Hale,
mm,
and her outputs are still very much, shaping the future of family law. So you can find the key people and read what they have to say about your topic. Or you can just go to the databases and go, surprise me, find me something that I can look at. And you can become very adept at reading the abstracts and reading the 3 lines or so that explain what the article is all about, and determining very quickly where you might want to put it in your essay. It might be that you don't use it at all. It might be that it's the one piece that really helps you break the back of the theory of the idea, and
mm,
it's the one that is going to get you the most notice by your examiners because it's the really key to understanding the topic. But research is never wasted. And these skills that you learn today, you are going to take into practice if that is your aim.
mm,
And there are many, many practitioners who are very eminent in their field. Philip Sands, for example, in international law. But I think of my own field, insolvency, and the late Gabriel Moss, who was one of the highest fee earners at the bar in insolvency work. But he was a prolific author who used to produce at least a dozen different articles a year. Some
wow.
case notes, some short pieces, but some published in the most reputable of journals.
Mm,
So this is a skill, a key skill that will help you navigate your way through a law degree because it helps you understand why the law and why it
mm,
exists and what it is used for. But it's also something that you will take into practice because you don't stop learning about the law just because you finish your degree. You will continue to learn the law all your life. And you have to learn to love the law as well and what it has to say to you. And the literature is part of this message.
very good, very good. I like that. And if you don't like what the law says, obviously we're going to go for law reform. But you still need to know your literature.
Exactly.
Oh, wow. This was brilliant, Paul. Thank you very much for coming here today, for imparting so much knowledge on this topic. And of course, if the students are willing to expand on any other points, then maybe we can have you back, Paul, for another one.
Oh, by all
Um,
means, by all means.
Thank you so much. And yeah, all the best to the students with all of the other brilliant podcasts that we've done so far. Take care.
Exactly,
Bye bye for
exactly.
now.
Bye bye.